Y'all remember this video of BIG30 sitting in his studio?
Street bullet, nigga. Who? Bird foot across the yard. Gonna wipe out the whole pod, nigga.
Right. Okay. Then do y'all remember this freaking phantom letter that just popped out of nowhere right here? Entertainment disclaimer for music, video, promotional, and related creative content. The lyrics contained in these songs are a form of artistic expression and storytelling. They do not reflect the personal beliefs, intentions, or real-life actions of the performer. Like many works in the genre, the content is designed to evoke emotion, depict fictional or exaggerated scenarios, and entertain audiences. Any accompanying music videos, visual content, promotional materials, or performances are likewise creative works intended for entertainment purposes only. Such content may include dramatized, fictionalized, symbolic, or exaggerated depictions and should not be interpreted as factual representations of actual events, conduct, or intent. The performer does not endorse or encourage any unlawful or harmful behavior referenced in the lyrics or depicted in any related visual content. The song and many accompanying media should be understood in the context of creative expression, where themes and narratives are often dramatized for artistic effect rather than intended as literal statements of fact or personal intent, for entertainment purposes only. All right. The fans said, you know what? Go ahead and record, get on the mic. And it's what they didn't do that people should be paying attention to. But no further ado, let's go. United States of America versus Rodney White Jr. Here we go. Memorandum, opinion, and order granting defendant's motion to modify conditions of release, meaning it's already good to go. See, what they go on to say is defendant Rodney White Jr. is charged with kidnapping and conspiracy to commit kidnapping in violation of 18 U.S.C. 12018 and C in a criminal complaint filed in this district. So, on April 6, 2026, Wright appeared for a detention hearing before the United States Magistrate Judge Annie Christoph in the Western District of Tennessee. But it's all fed, so it doesn't really matter. Just bear with me on this one because it's going to make sense for the Lil Durk video I link at the very end of this that you must watch because I destroyed the hell out of the feds. Anyways, it goes on to say that BIG30 is out on a $100,000 bond and Wright was released subject to conditions that include travel restrictions, no contact with co-defendants, firearm restrictions, drug restrictions, location monitoring, and home detention. The government moved to revoke the pretrial release. And then the court said, hell no, finding that the government has failed to establish that Wright is a flight risk or that the conditions of release imposed by Judge Christoph will not reasonably be assured. You know what I'm saying? Meaning, hey, y'all said all this stuff. I don't believe you. So Wright has now moved to modify the conditions of his pretrial release and basically say, permit me to go to these places, to a local recording studio, and also allow me to chat it up with my label. And then the government basically said nothing. So the government didn't take a position at all. And for those reasons set out below, the court grants Wright's motion to modify the conditions of pretrial release to permit local studio recording for employment purposes. Unopposed, you say. Let him go out and do all of these things, you say. I want y'all to see if you can catch it because it ain't to be caught. They ain't saying shit about one particular thing that starts with an L and ends with an S. Roll it. And it says, well, the government does not seek pretrial detention under 18 U.S.C. 3142 detention may only be considered on the court's own motion in a case that involves a serious risk that such a person will flee, which they already said he won't, and then a serious risk that such a person will obstruct or attempt to obstruct justice or threaten, injure, or intimidate or attempt to threaten, injure, or intimidate a prospective witness or juror. Where neither the government nor the court seek pretrial detention, the court is required to order the pretrial release of the person on personal recognizance or upon execution of an unsecured appearance bond in an amount specified by the court. And y'all can go on to see why they trying to say we got a whole bunch of shit from him And if he goes and steps out of line, we're going to screw him over because we got DNA and all this stuff. And if we release him and all this stuff, it's going to be personally all right because he's not a threat. Then he goes on to say the judicial officer may at any time amend the order to impose additional or different conditions of the release. But basically, really, if Big 30 messes up, they're going to bring his ass back to jail. You ain't got to worry about nothing. So make sure that you know that you're skating on thin ice, buddy. And then it says, in setting conditions under all of this stuff, the court task is to identify and impose the least restrictive combination of conditions that will reasonably assure, not guarantee the defendant's appearance. Basically, show your ass up to court. Don't really be a burden on the court, and you're going to be all right because you're not going to court until February. Anyways, they talk about the Bail Reform Act and all of this stuff, and it basically goes on to say, you know, the money is very important because Big 30 was able to show everybody, hey, bro, I got $1 million waiting for me when I get up out of here. And the court is like, well, you can use that $1 million. We ain't got to use our shit anyways. So it says, rather as explained above in setting conditions under section 3142C1, the court task is to ascertain and impose the least restrictive shit. They're just going on to basically say, hey, man, if you're employed, you have a job and all this shit, it's not really on us to say that you can't work. And then you absolutely showed right here where they go on and say he explains that he is employed as a recording artist with Endless Entertainment under the professional name Big 30 and is expected to have ongoing professional obligations that include delivery of master recordings, music videos, marketing participation, promotional participation, media obligations, and related commercial exploitation activities that created a need for access to professional recording studios and production personnel in the Memphis area. I would have been curious, though, if the feds would have reacted to this shit. Then it goes on to say, Wright further suggested the following safeguards to limit the proposed modification. Basically, let them know when I'm going, the studio that I'm going to, the roads that I'm going to go there. I'm going to keep my GPS powered up. I ain't going to talk to nobody. I ain't going to have no guns. And I can't do no concerts, live performances, promotional appearances, music videos, shoots involving public crowds, clubs, bars, or public events, unless separately approved by the court or pretrial services. So technically, he kind of can, as long as these people know. Then it says authority for pretrial services to deny, limit, shorten, reschedule, or revoke any studio approval, and pretrial services determine that the session is inconsistent with supervision, safety, or the court's conditions. Then it says these additional safeguards largely mirror the existing conditions imposed on Wright, such as travel restrictions, no contact with co-defendants, and guns and all that. Basically said, you were already allowed to do a lot of this shit, so it ain't really going to hurt us to allow you to do any of this stuff. So the court determines that permitting Wright to access a recording studio subject to both the existing conditions and safeguards set above is good with us. So these reasons explain he good. He can go ahead and leave, go to a residence. He can basically start booking recording sessions. So if you start seeing his promos and all this shit, you definitely can pay for it. You definitely should get a Big 30 verse. And then it says, just go straight to the studio and come back. And there you go. He says, well, it says, make sure your GPS is charged. Don't go anywhere you ain't supposed to. And then don't have any contact with anybody. And obviously no guns and all this shit. And really, they could say, if you book a studio session that's like 12 hours and all this shit, we can knock it down to 8. Just check in with us before you do. And it is dated July 7th, 2026. The feds never state in that damn motion granted by the judge. Well, the judge never says it. The feds never even said, hey, we need approval of what it is that you say. Y'all don't find that interesting? Hold on, is my mic on? My mic on? My mic on? Is the phone working? Is the cameras working? Is the computer working? Is the laptop working? Is the internet working? The feds didn't even say, hey, bruh, you can work. Just let us know what you're working on. They just set Big 30 ass up, man. They did. They did. When the feds didn't file a motion to basically say no, or they didn't say you can rap in your house, which in the first clip you seen him rapping in the house, when that wasn't a thing, it wasn't stipulated, nor none of this shit, then they like, yo, bro, Technically, you could go do shows. Technically, you could go do appearances. Technically, you could do all of this shit, but just let us know what you're going to be doing. Means hit us off on what it is that you're going to be going to, so that way we can extra monitor that. Please remember, note and know that this is an ongoing investigation. They're not stopping. Tell the truth, you want to like a real crash dummy. What down? Those lyrics will be used. If Gucci Mane takes the stand, they're going to play the damn song of his. If Big 30 jumps out of his body and basically does some dumb shit and talks about anything that resembles anything close to this, they're going to fry him like hard-cooked eggs. So in my opinion, if I were to ever speak to Big 30, I would say, hey, bro, listen. You know, I know, everybody else know, you're going to jail for a little bit. You're going to the federal penitentiary for a little bit. So it's best that all your lyrics, all your songs, everything that you're doing, that it stays where it needs to stay, aka the vault, until you get sentenced, until all of this shit is done. Now, some of y'all will go with Nash, what sense does that make? It makes legal sense. Because in my thoughts, in my belief, I believe the feds is like, man, come on, man, run that shit. Yeah, run that shit. Where all my thuggin' ass killers at in studios with Dracos, finna run that Gucci bag, and we gon' film all that. Give that shit, sign that shit. Film that shit. Save that shit. What? Nah, let me stop. But nah, on a serious note, bro, I think the feds is like this, bro. Go ahead. Just say some stupid shit so we can use it against you. I believe the feds are setting him up. Because if they don't get him with the studio shit, they're going to try to catch him at a show. They're going to try to figure out any way they can stack charges on this. You don't think the feds want to give Big 30 more shit? And some of y'all will go, well, Nash, the Big 30 shit, as far as the video goes, that came from his phone. You'd be correct. But then it gets deeper because Big 30 wasn't the one who released the shit. That video was supposed to be promo. I don't give a damn what anybody else is saying. That video was not shot to make Gucci Mane look like a buster. That video was shot to absolutely have people believe, and in the belief system that Gucci Mane dropped Pooh Shiesty from the label and let him get his own thing running. That video was designed to come out, just not in that way. It is what it is. But hey, y'all, let me know your thoughts on this one. Are y'all sinister as I am and y'all thinking to yourselves, bruh, they trying to set Big 30 ass up to say some shit or place him in a place he shouldn't be? Or are y'all of a different mindset and y'all like, man, it's just rap, bruh. They already put out that letter, so that letter is going to carry him on. Because nowhere in this indictment is it talking about lyrics. Either or is perfectly fine. I don't know. But y'all, let me know your thoughts on this one. Click right here, though, to see how Pooh Shiesty's ex-lawyer, confidant, but Kodak Black's lawyer, how they're trying to spin it to win it. I actually agree with Bradford Corn on certain things, and then we blow his ass out the water. Click right here for that video or click right here for the playlist, and I will catch y'all in the next one. We are 10K away from the Xbox and PlayStation giveaway. They're way over there. I just didn't want to put them in the shots. So, hey, y'all make sure y'all subscribe today. We are 10K away. We'll catch y'all in the next one.